Please be seated.
Good morning.
Good morning, Your Honors, and Chief Justice Ireland and Justice Duffley. Congratulations on your historic appointments. May it please the Court. I'm Assistant Attorney General Iandra Goldberg of the Massachusetts Attorney General's Office, and I represent the appellant, the Massachusetts Department of Environmental Protection.
Just one moment, please. Start the clock. Thank you.
Thank you, Your Honor. The Massachusetts Department of Environmental Protection in this case, in which the appellee, Entergy Nuclear Generation Company, is challenging the Commonwealth's regulations with respect to cooling water intake structures at power plants within the Commonwealth.
Could I just ask a factual question? Is it the case that this regulation simply says we've got the authority to regulate?
Your Honor, it is the case that the regulation simply states that we have the authority to regulate.
So it doesn't really, there's not a whole lot of substance to it other than the assertion of authority? I mean, I understand it then says you've got to do this stuff.
Well, actually, so beyond the mere assertion that we are authorized to regulate withdrawals by cooling water intake structures, it does go on to say that that regulation would include applying the surface water quality standards to the operations. But basically, at bottom, what the regulation says and what it was designed to do was to merely identify for the regulated community that, in fact, we have and will continue to regulate cooling water intake structures in the course of drafting our state permits and working with the federal government.
You issue state permits for intake?
Your Honor, the Commonwealth, the Department of Environmental Protection, under its statutory authority, issues state permits with respect to power plants and other dischargers. Yes.
Do you issue permits for intake?
Yes, we do.
Okay.
We issue permits that address the intakes at the cooling at the power plants.
But they're really,
we do not.
They're really dealing with, I mean, they're really dealing with effluents, right?
No, Your Honor. I mean, at bottom, that is what this case is all about, for sure. The authority for the regulations goes well beyond merely effluent.
Not about the authority, just sort of, that's what triggers it, is the fact that there's...
Oh, yes. There is no question that what triggers the permitting under the State Act, under Chapter 43, Chapter 21, Section 43, is either a discharge of pollutants into the waters or an activity that is reasonably likely to result in a discharge of pollutants. Yes, I'm sorry.
Oh, I just had one other factual question, which is you say a couple of times in your brief that quite apart from this regulation, you have been doing this in the context of individual permits. Is that correct? Do I have that correct?
Yes, Your Honor.
And how does that come up?
Well, Your Honor, within the context of the permitting for Entergy and for the predecessor in interest to Entergy Boston Edison, it comes up within the context of the federal government and our state government working together on permits to provide for the requirements to prevent the fouling of our waters. And those requirements have historically included regulation of cooling water intake structures. And historically, both the state and the federal government has applied the Rule 316B standard of how they review the cooling water intake structures.
So part of a permit is going to indicate that you're applying the water quality standards to this particular activity? I mean, that it says so in the permit?
Yes, Your Honor, it does. And if I can direct the Court's attention to the permits, I mean, it may make sense just to spend a moment looking at the permits themselves. So if we look at the record,
Okay. Yeah.
I'll read from the record.
Okay. I've got the brief, but I don't have the record.
Yeah. In the appendix at 669, we have the initial joint permit that was issued to Boston Edison by both the federal government and the state. And it says that it's issued under a federal permit number and a state permit number. It's a joint state and federal permit. And it's issued in compliance with both the federal law and the state act. And it authorizes Boston Edison to discharge from the facility in Plymouth in accordance with effluent limitations, monitoring requirements, and other conditions set forth in the permit. And in the permit itself, actually on the subsequent page, it provides that the location, design, construction, and capacity of the cooling water intake structures shall reflect the best technology available.
And is that under the Clean Water Act? Is it specified, or is it under the Water Management Act, and does it matter?
No, actually, that is under the State Clean Waters Act and also under the Federal Clean Water Act.
Okay.
If this case doesn't present an actual controversy, what element is missing? And hasn't Pilgrim been subject to DEP's alleged authority over CWIS for 35 years?
The crucial element that's missing, Your Honor, is the element of uncertainty. Declaratory judgment was designed to address risks of uncertainty for a litigating party. In this case, there can be no risk of uncertainty. First of all, as we've pointed out, just looking at the initial permit, and just so that the record is clear, not only does that permit provide for the regulation of cooling water intake structures in terms of their location, design, construction, and capacity, which is kind of the overall gestalt of how the cooling water intake structures can be built. But the permits also specifically do address activities at both ends of the cooling water intake structure. The permits that are obviously in the appendix show that there is the discharge of chlorine and which is a biocide that comes as a result of the cooling process. The permits actually have a limit, I believe, of 457 million gallons a day of discharge of cooling water from what's known as outfall 001. So it's not that this is cooling water that comes into the facility and kind of circulates around the facility and never finds a way to get discharged from the facility. Actually, this is a once-through cooling process, and we have millions of gallons a day that are authorized to be processed through this facility.
Well, does that mean that if the – I'm sorry, why don't you finish your answer?
Yeah, no, that's fine. I'm sorry, Your Honor.
Does that mean that if the facility received its cooling water not from the ocean but from the municipal water supply, for instance, and there were chlorine in that water, that you could regulate through this process the manufacture of the chlorine chemical that happened to be used in the municipal water supply?
Your Honor, we wouldn't be suggesting that we could regulate the manufacturer of the material that the power plant chose to use.
But why not? Doesn't it logically flow that you could do that?
At bottom, the authority is tied to activities. At bottom, it's the power plant, Your Honor, that is regulated. And at bottom, once the power plant has discharged or is engaging in an activity that is likely to result in a discharge, then the permit conditions kick in. When you look at the state authority for those permit conditions, it clearly provides that the department has the authority and actually the responsibility to enhance the quality and value of our waters, and it provides that in doing so, it cannot issue permits that either violate federal law, and it must issue, and it has the discretion, the department has the express discretion, the discretion expressly stated within the permitting statute, Chapter 21, Section 43, to include conditions in the permit that the department deems necessary in order to protect the quality of our waters.
I'm trying to figure out what's going on here. The federal government specifically regulates this, specifically in its statutory authority regulates this. Do you want to do something different? Is that what the point is? We want to create a whole new set of standards for these?
Well, could I add one question to that? Are you saying that EPA's CWIS regulation is inadequate?
Your Honor, we are not saying that the regulation is inadequate. What we're saying is that the way that the NPDES, the National Pollutant Discharge Elimination System program, is designed is, in the first instance, to have the federal government apply technological standards to protect the waterways. But a crucial second component, and actually this second component came first in history, is for the states to protect their own water quality because of...
But you can already do that under the existing, under the regulatory scheme that existed before this particular regulation was promulgated. Couldn't you?
Exactly.
So what does this do? What does this regulation do other than make the federal government happy?
What would you do with this authority that EPA can't do under the Federal Act?
Justice Spina, what the regulation does is it merely was, it frankly was a throwing of a bone to the federal government in terms of our making very clear in a regulatory record this authority that we have been, that Mass DEP has been exercising.
You say you've been exercising it with the federal government
Yes.
for 40 years, but
Correct.
the federal government says, no, you're not. And now you're saying, oh, yes, you were. What is this? What is it?
Your Honor, it's not that the federal government says no or not. It's that the federal government wants for us to be pronouncing what our authority is. It's very clear, Your Honor, that the permits in this case and the permits issued to power plants throughout the Commonwealth have included these restrictions, and they've included these restrictions that and they've included these restrictions in the permits in ways that ultimately, if the cooling water intake structure is going to be changed, that not only EPA must approve that change, but again, the permits specifically say that DEP must approve that change.
Is it your view that under Section 27, subsection 3, which says that your division shall take all action necessary or appropriate to secure to the Commonwealth the benefits of the Federal Water Pollution Control Act, that incorporates by reference the authority of the division to regulate under federal law all that the federal law regulates?
No, Your Honor. The way that the program is designed is for the states to be able to have is for the states to administer the federal NPDES program. We're not asserting
Which you don't.
What we're not asserting is that a delegation happens, and by being delegated the ability to administer the program, that we then have the authority to act as the federal government. Rather, the way these program works and other similar programs where the states are granted primacy, the way that it works is that before the federal government will grant primacy to the state or delegate that authority to the state, the federal government makes the determination, and the Attorney General's office also makes the determination in a letter to the federal government, a certification, that in fact the state has the authority to regulate in the same way that the federal government does under the statute, and to be able to apply the statute to permits in the state.
So you're telling me then that the statutory authority for this regulation does not derive from subsection 3, but derives from subsection 6 of section 27.
Subsection 6, Your Honor, also subsection 12, in which DEP shall adopt regulations which it deems necessary for the proper administration of the laws relative to water pollution control and to the protection of the quality and value of water resources. And it derives from the overall Enabling Act's requirement that it's the duty and responsibility of the Department of Environmental Protection to enhance the quality and value of our waters, as well as to establish a program for the prevention, control, and abatement of water pollution.
So if we were to say that, that you already have, the state already has this authority to do this, you don't need this regulation, and we do not see the legislative source for this particular regulation, what are the real consequences of something like that?
Well, here's my real concern with your question. Part of your question heartens me, because we agree that this regulation really substantively does nothing. My concern with your question, frankly, is that the way that that question is addressed could leave a real uncertainty as to the department's authority to regulate these structures, which are so clearly in need of being regulated from the state level.
But nobody's questioned that in 40 years.
Exactly. And that's why there's no uncertainty here. And in terms of the question as to whether there is any uncertainty that needs to be addressed, there can be no uncertainty, because for 40 years and for many years under these permits, cooling water intake structures have been regulated under 316B. Regardless of whether it's the state doing it as a delegated entity, or whether it's the state and the federal government do it jointly as it is here, or the federal government saying, you know, the state, you're not doing your job. In any event, the standard that's going to be applied, one way or the other, is 316B in terms of regulating these structures.
What are the real consequences vis-a-vis the state's relationship with the federal government to our saying that this regulation is meaningless?
I'm not concerned about our, frankly, Your Honor, I'm not concerned about our relationship with the federal government. We haven't obtained delegation. We're not seeking now to obtain delegation. We do our job. We, the Commonwealth, and the Department of Environmental Protection does its job to protect the quality and value of our waters. That's what I'm concerned about. If you were to say that we didn't have authority, I wouldn't be worried that we can't get the program delegated. I'd be worried that then, when we have an administration in Washington that isn't caring about the quality of our waters, but we have our Department of Environmental Protection that always does, that would throw into very serious question whether we can do our job, which is to protect our waters. And under the system as it now exists, it is the state's job to protect our waters. Under any circumstance, through a variety of means, the federal government looks to us to make sure that our own waters are protected, both with respect to cooling water intake structures and otherwise.
Why did DEP decide to promulgate the regulations at the particular time they did?
It did arise out of the most recent triennial review. It arose out of a lot of
pressure from the federal government. It's all over this place. Pressure from the federal government. You say you don't care about the federal government. That pressure is meaningless.
Well, perhaps it's easy for me to say that in front of your honors. Maybe it's not so easy for my agency to say that when they're sitting in the room. But at bottom, it's...
Well, then it isn't sensible to say it to us. If that isn't what's going to happen in the real world, you do care about it.
And actually, we do care in that the worst case scenario is, and I'm glad you pressed this, the worst case scenario is that the federal government were to decide that we're not doing our jobs correctly, in which case they then could step in and regulate our state themselves, and that is the worst case scenario.
Your time is up.
Thank you, Your Honors.
Good morning, Your Honors. Chief Justice Ireland, and I'd like to add my congratulations to Mr. Goldberg to Justice Duffley. My name is Gwen Williams, and I represent Entergy Nuclear Generation Company. In light of some of the questions that your honors were asking, I'd like to actually dive right into some of those questions rather than start where I had planned to. And let me start first with some of Justice Cordy's questions that he had for Mr. Goldberg about what's actually happening with the regulation here in terms of who's regulating, DEP or EPA. Justice Cordy asked Mr. Goldberger about the existing permits for the intake. And I want to be very clear about this point. I know that your honors may not have the permit in front of you. But when you look at these, what I want to point out to you, and it is at page A670 of the record, is the permit is a permit issued pursuant to the national program, the NIPD's permitting program. And it is jointly signed by both DEP and EPA. That's because both agencies play a role with regard to different pieces of the permit. Just because DEP's name is at the bottom of the page doesn't mean that they have the regulatory authority to deal with everything that is in this permit. And specifically, with regard to the provision in the permit about the intake structures, it specifically references that approval with regard to the cooling water intake structure for Pilgrim is pursuant to federal Section 316B. So the fact that DEP's name is on it doesn't change the fact that the regulation, the law that is being applied in this permit is the federal law. Now, Mr. Goldberg also said towards the end of his argument that that what the concern is, I think, what the state's concern is that the standard, whether it's EPA or DEP, the standard to be applied is 316B. Well, that is not what the regulation that we're challenging here says. The regulation that we're challenging here quite clearly says something entirely different than the state will just apply 316B. What it says is that the state says it has the authority to impose conditions on the intake structure in order to comply with any of Massachusetts surface water quality standards.
Why shouldn't you wait until there is a surface water quality standard that you think is a problem? I mean, I guess I am troubled by why this is a controversy right now.
Sure, Your Honor.
Because there's no indication from the state that it has any intention whatsoever to look at or change the permit that requires you to keep up with, with the most effective technological CWIS that there is, or whatever it says.
Yes, Your Honor. Two points with regard to that, to the actual controversy point. First of all, the state does not have authority under the federal act even to apply the 316B standard. So regardless about, let's put aside for a moment, my second point will be, what is the standard to be applied? The first question is simply, who applies it? The way the federal law is structured, Congress gave the power to EPA. That is not a delegation of power to a state agency. Federal law cannot delegate power to a state agency. It's axiomatic, of course, that, right, of course it could, right. So EPA has and does exercise the power to regulate Pilgrim's cooling water intake structure under 316B. So first of all, even if what the state wanted to do was say, we want to apply 316B standards, it does not have the regulatory delegation of powers to do so.
Not unless it becomes the
not unless it either becomes the permitting authority, or if there is an express delegation of power from the Massachusetts legislature to the state agency to regulate cooling water intake structures. The second piece of the answer to your question is okay, what's the standard? Pilgrim, I think this is the critical question, and it's the way in which this case is very different, for instance, from the Stop and Shop case that the state relies on heavily about the actual controversy point. In Stop and Shop, you had a party who was thinking that they wanted to apply for a permit. They had not yet applied, and of course, who knows whether they might have been granted the permit, in which case there never would have been a controversy. Here, we have an existing cooling water intake structure that's been regulated for many years now, subject to an existing permit. And critically here, that permit is up for renewal. The permit is in the middle of a renewal process.
So why don't you wait and see what happens?
Because the permitting process doesn't work this way. You don't submit an application and then not hear anything from the pertinent agency until you get an approval or a denial or conditions. The way it works is that the applicant works with the agency through the process to submit information, to address any concerns. It's a real back and forth process.
So are you having trouble with that right now?
No, the process has been going on now actually for many years, and the current state of play is that information has been submitted as EPA requested. But the point is, right now, or up until now, Entergy knew who it needed to deal with in terms of that renewal process. It was EPA. If DEP is now saying, wait a minute, we want to play with regard to this permit as well, now you have the uncertainty, which is the basis of what the Declaratory Judgment Act is aimed at addressing, is giving parties a way to resolve uncertainty. And we have that uncertainty right now about both what standards are to be applied. Is it the 316B standard, or is it something more nebulous, this assertion that the intake structure can be conditioned on anything to do with the Massachusetts surface water quality standards, and also the question of who is it that is regulating? Is it just EPA, or is it EPA and also DEP?
So if right now you claim the state could say that you have to do better than the best available technology, that you have to do something beyond that, I mean, that's a pretty tough standard as it is, the best available technology. Are you fearful that the state will ask you to do more than that?
Well, the state, of course, cannot ask us to do anything less than that, but it's really apples and oranges in some respects, Your Honor. The federal standard, you're right, is the best technology available to minimize adverse environmental impacts, and that's a standard that has a considerable amount of law around it. It's been administered, obviously, for quite a long time. It's administered by EPA in its best professional judgment. And while obviously with regard to any specific case, people may disagree about the proper application, in general, people in the regulated community basically know what that standard is and how it's applied. What we're talking about, what the state's challenge provision says is, again, it's quite nebulous. It's saying we've implemented this new regulation. The regulation says we DEP have the power to place conditions on your intake structure. Any condition that we want, as long as it would further something, it would be consistent with something in the water quality standards. Well, the water quality standards then, so what are those? Well, water quality standards basically are of two types. They are either numeric criteria or they are narrative criteria based on designated uses. So the state has assigned a designated or a best use to certain bodies of water, and you basically have to live up to that best use. You can't do anything that would be in derogation or would cause the body of water not to live up to that standard anymore. So it's really a whole different way of looking at things, and could lead to the imposition of different conditions. Of course, it couldn't be any less stringent than the federal standard, but they
so
can be different and more.
You're fearful that they will take this beyond best available technology. I mean, and then if that's the case, why should we not wait until they do? Because right now, all I hear them saying is they want to ensure best available technology, and they're concerned that there will be an EPA administration which will no longer meaningfully enforce that obligation, and they want to protect state waters when the feds may not be doing it. That's what they're saying. I don't hear them saying we want to go beyond best available technology. I hear them saying we want to make sure the DEP is there when EPA really isn't.
Well, first of all, Your Honor, you're right that you didn't hear Mr. Goldberg saying that, but of course, this is a regulation that we are challenging as a matter of law. Does the agency have the authority to promulgate this or not? It doesn't depend on the validity of the regulation, does not depend on the way in the future the agency may choose to apply that regulation. The question for today simply is, did the agency have the power to promulgate that regulation? And it can only have the power to promulgate that regulation if it has been explicitly granted that authority by the state legislature. Concerns that the agency may have about something that had happened in the future about the federal government not being adequately protective, if DEP has that concern and it wants to play this role, or at least be in a position to play this role, the proper avenue is for it to go back to the legislature and have the legislature ask the legislature to pass the appropriate enabling authority. It isn't simply to assume that, although we think the EPA has done a perfectly fine job for these many years in regulating the cooling water intake structure, we're worried something may happen in the future, and so we're going to hereby assume this authority. if it's not been granted by the legislature. Again, the touchstone has to be the plain language of the statute. What was the legislature's intent in passing the act? And everything in the act quite clearly relates to discharge. Nowhere in there.
I mean, certainly Section 6 does, but he references Section 12, which gives the DEP the authority to adopt regulations for the protection of the quality and value of water resources. Now, it seems that the withdrawal of water and the killing of marine life does relate to the protection of the quality and value of water resources. So why can't Section 12 be adequate authority for them to protect the marine life, which may be at risk here?
First of all, because things like savings clauses, which that functionally is, or preambles, first of all, they don't operate to convey more power than the legislature intended to convey in terms of the actual, the heart of the act, if you will. The heart of the act is quite clearly related to discharges. Excuse me, Your Honor. And let me go back to what I think is really critical to this analysis about what the legislature here intended. The chronology here is quite important. In 1972, the federal government passed or amended the Federal Clean Water Act, which is what put this 316B provision into the law for the first time. In 1973, the Massachusetts legislature then amended directly in response to the Federal Clean Water Act, which we know from the record, it's in our record. For instance, there's the accompanying statement by then Governor Sargent sending the bill to the Massachusetts legislature makes quite clear that this act is in response to the federal act. If the state legislature had intended for DEP to regulate intake structures, it would have simply included a provision just like 316B, which is one of the things it was responding to. And many other states that do have the state agency regulate clean water intake structure did exactly that. They put a 316B provision right in their enabling legislation.
Can I ask you this? Doesn't the regulation of the water intake affect receiving waters?
Anything, I suppose, if you go far enough back up the chain, can affect it. And I think this is what Justice Spina was getting at in some of his questioning earlier. Where do you draw the line question?
Okay, but the statute says that the director's permit can look at effluent limitations and also conform to regulations, receiving water standards, and et cetera. So why wouldn't that bring in the water quality standards into the permit?
Well, they have to be with regard to discharges still. It's still the touchstone of the act is about discharges.
It says effluent limitations specified in the permit and will conform to regulations, receiving water standards, and comprehensive plans adopted by the division. That's much broader than just discharge standards.
Well, those are water quality standards which the agency was given permission to create under the Massachusetts Clean Waters Act. So it's not something broader than that. They're talking about water quality standards.
But we're talking about water quality standards also, right?
Under the State Clean Water Act, which is about discharge. I think it's also important to note that the legislature does know how to give authority to regulate withdrawal when it so chooses. There is a whole separate statute about regulating withdrawal, the Water Management Act. The legislature, and right in that act, the legislature defined withdrawal, which is obviously quite different than discharge. It is, in fact, the opposite of discharge, and it's defined in basically that way. So the legislature knows how to regulate withdrawal. It chose to regulate withdrawal somewhere else. This is a case from another jurisdiction, but I think it's somewhat helpful on this point. There's a case from Colorado called Colorado Wild, where the court there was examining the interplay of Colorado's statutory system, which is quite similar to this. Two statutes, one about water management, in other words, quantity of water, withdrawal of water, and another about sort of the state analog to the Federal Clean Water Act, about water quality, like our state act here. And the court there concluded that where you have these separate systems, you can see that the legislature intended to regulate one thing in one place and another thing in another place, and that therefore water quality standards promulgated under the quality of the water statute, the Clean Water Act, are not intended to encompass things to do with intake, but rather only with discharge.
What does the state act mean by requiring permits for activities indirectly discharging pollutants?
So indirectly is not defined in this particular piece of the statute, but again, all of the language of the statute, again, goes to discharge. So we're talking about something that is indirect discharge. Again, this is the question of how do you know where to draw the line. I think it's instructive on this point that the EPA itself, on its website, talks about states that have where the enabling authority talks about both direct and indirect discharge. So EPA says what it thinks direct and indirect discharge means, and what EPA says indirect discharge is. It has to do with emissions from non-point sources. So in other words, ground runoff. The federal act only regulates point source. In other words, for instance, an industrial facility which is discharging directly into a water body by way of a pipe or a canal, things like that. Non-point source is not governed by the federal act, but it can be governed by the state. And so a much more plausible interpretation of what the legislature meant by indirectly discharging would be these non-point sources that the federal government did not have the power to regulate, but the state does.
Is it your view that if this regulation had not been promulgated, that the state of Massachusetts does not have its own authority to regulate water intake at one of these plants?
Certainly not under the Clean Water Act. There is, again,
under any source.
Well, there are many other statutes that deal with the intake of water in a specific way that's pertinent to that statute. So, for instance, the Endangered Species Act may regulate withdrawal of water if it pertains to an endangered species issue.
And was this facility regulated under that statute?
This facility, so probably, as I mentioned before, the Water Management Act is probably the most sweeping of the acts, of the state acts that would deal with water withdrawal. And this facility is not regulated under that because DEP has chosen not to apply its water management powers to plants that withdraw from the ocean. It does apply if you withdraw from fresh water, not if you withdraw from the ocean.
So this particular facility has not been regulated under state law up until now, has not been regulated under state law for purposes of intake, water intake.
That's correct, Your Honor.
Well, they would say they have.
They would say they have. We would say it was EPA.
But you're saying essentially that what they regulate is, among other things, the killing of fish by the discharge of pollutants, but not the killing of fish by the method of withdrawal of the water into the facility.
That's correct. That's what we believe, that the Massachusetts legislature delegated the authority to DEP, and if the legislature wants to delegate authority to DEP to regulate on the intake structure, then it could have done exactly what the federal government did and what many other states did, which is include an express provision saying so.
Well, there's a joint EPA-DEP Pilgrim permit back in 1975, correct?
Yes, it's been joint through that whole
Right.
period.
So does that demonstrate that there's been DEP oversight of CWIS back to that time?
No, again, Your Honor, that's where I started with. The fact that DEP's name is on the bottom of that permit, which is, you'll see if Your Honor looks at it, I mean, it's quite long. It addresses many, many things. It has some very technical details. The fact that DEP's name is on the bottom of it as well doesn't indicate that it was properly granted regulatory authority, and in fact was exercising that regulatory authority over every single thing in that permit. It is simply a somewhat unusual artifact of the fact that Massachusetts is one of the very few states in the nation that has not applied for and received delegation from the federal government to permit its own discharge program. So instead of the NPDES permit being granted by EPA, in most states they've applied for state authority, and that is done without EPA's direct involvement, though they do have oversight over the process. It's just an unusual circumstance that we find ourselves in Massachusetts, where EPA most directly is the permitting authority and is the only permitting authority as to cooling water intake structure. DEP has a different role to play, and they come together in this one document so that the plant is bound by this one document, but that doesn't say anything for this court about whether the legislature had intended to delegate authority on cooling water intake structures to the agency or not.
Thank you, counsel.
Thank you, Your Honors.